Hello, you're listening to a recording of a presentation on data protection in the workplace and how it works in practice, given by Rachel Masterton, Guernsey's Deputy Data Protection Commissioner. This took place at the offices of the Data Protection Authority on the 4th of September 2019.
Welcome everybody, so thank you all very much for coming. I'm Rachel Masterton, I'm the Deputy Data Protection Commissioner, and I'm going to be taking the session today talking about data protection in the workplace. Today's aim, the aim of today then, is to give you a sense of how data protection works in practice. So we can do lots of talking about the law, and I can tell you which section such and such happens in, but that's actually not necessarily particularly helpful. What you need to know is, how does this work in practice? What do I need to do in order for our organisations to be compliant? So we will take you through that today. Now, we've used the word sense because it is about 260 pages of legislation plus additional bits of paper. So in an hour, best will in the world, we're not going to cover everything in huge great detail, but this will give you key things you need to think about, guide you through the steps you need to take in order to grasp the data protection legislation and look to demonstrate your compliance. There will be other sessions that will go into various aspects in more detail. If you aren't able to make any of the future ones in this, you can look to get on the next set. That's there. So the things we will be looking at then is basically an overview of data protection and privacy. So what's it about? Then looking at what you need to do in practice and taking in line with that, at the same time as that, looking at how you can achieve compliance and demonstrate compliance. Within the data protection law, there are 7 principles. There were 8 previously. They've been rewritten slightly, so there are now 7. And one new principle, the final principle, is about accountability. And you need to be able to demonstrate that you are doing the things that the law requires of you. So it's not good enough to be able to say, oh yeah, but we've had a thought to think about that. You need to be able to demonstrate that you are taking this on board, that you're doing various things, that your organisation is accountable. And so we will be looking at what that looks like in practice. We've got a couple of activities for later on in the session. We'll split you as the 6 tables. 3 tables will be given one activity, 3 will be given another. You'll be given time to discuss the activity on your table, and then we'll do a feedback session at the end. So you can look at how these things work when you're back at your desk trying to work out what you need to do next. So what is data protection? Well, data protection is a piece of legislation that strikes the balance between the desire individuals have for their data to be protected, for it to be handled appropriately, but the needs that organisations have in order to do their job. They need to be able to use some of this information. So the law itself gives individuals a number of rights about how their data is handled and that they can exercise themselves in order to understand and to have some level of control over the data that's being used by organisations. It also places obligations on organisations to use data in an appropriate fashion and to have lawful reasons for doing so, and we will look at what that looks like as we go through. We would like to think of data protection as not being a blocker to business. If you want to do something that is common sense and straightforward and seems reasonable, then data protection is unlikely to be the thing that stops you from doing that. If you're going to go and be something weird and wonderful and new and novel, you need to maybe look at it in a bit more detail. But if you can think, if it seems like it should be common sense to be able to use that for something, then data protection is unlikely to be the blocker. Unfortunately, it is sometimes used as a blocker, and that's often more because somebody doesn't want to do it than because the law itself doesn't allow it. So you just need to look at it and embrace the legislation. And the legislation locally is, of course, the Data Protection Bailiwick Guernsey Law 2017, which has been drafted to be essentially equivalent with the General Data Protection Regulation, the GDPR, that came into force on 25th of May last year, amid quite a lot of fuss and interest for data protection legislation. I'm sure the legislation, previous iteration in 1995 across the EU, did not come in with quite such a fanfare. So now it's on the forefront of individuals' minds as well as organisations, which can only be a good thing. Data protection is all about personal data. So personal data is information that is related to an identified or identifiable individual. So if you can identify a person from the information you have, then that information becomes personal data. It's important to remember personal data is all the good factual information you have, but it's also opinion that you might be recording about people. And the HR space is somewhere you look to quite a lot. You see quite a lot of opinion about people. When you're assessing people for jobs, for example, you will be writing down how you thought they performed, what your thoughts were about that. It's important to remember that opinion is personal data, that individuals have a right of access to that information, and that it needs to be clear when information is opinion and when it is fact, so that you can take on board and judge it as you will. So I might assess something in one way, my opinion is this, somebody else's opinion might be different. That's not the same as the factual stuff about I am this person. You just need to take that on board. Then in the box on the right of the screen you have special category data. This is data that bears a striking resemblance in most part to Article 14 of the European Convention of Human Rights. And I can see you all sitting there going, oh yes, I've seen that list before. The things that people are more sensitive about, most of it was classed as sensitive personal data under the previous iteration of data protection legislation. And where you are processing special category data, you need to take a little bit more care. Have some more extra steps from within the law kick in. There are some additional requirements, so you need to be able to identify where you've got personal data, just the bog standard personal data, but where you've got special category data, be aware that you may need to take some additional steps around that. So we're going to spend some time going through some steps about what you need to do in practice and how those practical steps can help you demonstrate compliance and ensure compliance in your organisation. There are 8 steps that we'll go through, and we'll be referring to the handout on your tables. You should each have a copy of that that you can take away, and that again we will provide again in the electronic format. So the first thing you need to think about is whether your organisation is a controller or a processor, or in some occasions it will be both. So a controller is an entity that determines the purpose and means of processing personal data. That's the entity that decides what they're doing. Why have we got this data? What are we doing with it? Makes all the decisions, takes all the responsibility around how that data is going to be used. A processor would be an entity, an organisation perhaps, that you ask to do something on your behalf. So looking at HR again, because it's quite a nice, neat example. An employer, we are a controller, the Office of the Data Protection Authority. I nearly forgot who we were then. This is going to go really well. Please don't send these to the board. So it's going to go, an organisation's, we're a controller, we employ staff, we want to make sure our staff are paid. But we don't do that ourselves. We get an organisation to handle the payroll, do that for us. They are a processor. We provide them with the information they need to know in order to pay our staff. They shouldn't do anything else with that data other than make sure that they fulfil the instructions that we provided to them. And it's important to understand your role, because different things will kick in. So if you're a controller and you have no processes, you need to make sure that you adhere to the principles and the other aspects of the data protection law that apply only to controllers. If you're a controller that employs processes, you need to make sure you have the appropriate contract in place between your organisation and the processor that outlines what you're expecting them to do, how you're expecting them to handle that they shouldn't do anything with it outside the instructions that you have provided. And asking is probably not the right word. If it's a contract, it's probably telling. Agreeing, perhaps, with them how that they will help you to be compliant with the legislation, how they will help you adhere to requests or deal with requests that you get in from individuals. It's also important to remember that in the most part, a controller or a processor will tend to be an organisation. The law helpfully refers to person, which is not necessarily terribly helpful. Person itself is defined in the law as being both an individual but also organisations. So in the most part, an organisation will be the controller. It will only be if you're a sole trader or joyfully a deputy or other circumstances like that where you would individually be a controller as one person. So once you know that, you can make sure you adhere to the various aspects of the law. You can write it into your data protection policy as it says on the handout, and you can make sure you have the appropriate agreements in place. The next step then, and the key step, is about understanding what you do with the data that you are processing. So you identify where you get it from. Do you get it just from the individual? Do you get it from any other sources? You understand what you use it for. Why have we got it? What are we using it for? What are we looking to achieve with this? You document your rationale for your decisions that you're making about how it's processed. You make sure you identify from Schedule 2 of the law one of the lawful processing conditions. Which condition are you relying upon? So Schedule 2 outlines a number of conditions, any one of which, in various circumstances, you can rely upon as the lawful basis. You need to be able to pick one of those. One of them is contract, so if you're employing staff, much of the information you process in relation to that will be because you've got an employment contract with that individual. If you've got contracts for service, then that again will be the condition you would look to. There are other things. If you've got a legal obligation to do something, there's a condition that deals with that within Schedule 2, and you need to be able to identify these. Consent is on there as well. Consent is the top condition, as in the one first on the list, but it is no better than any others, and in some circumstances you would be better to seek a different condition rather than relying on consent. Consent not kicks in additional rights individuals have, and they always have the right to refuse consent and to take consent back again. So have a look through the list, see which of those lawful processing conditions is most appropriate. When you're looking at how you're using data, if you're straying into the realms of special category data and you're processing large-scale amounts of special category data, you need to be doing what's known as a Data Protection Impact Assessment, a DPIA. That is sitting down and looking at all the things, how you're using the data, all the risks that there will be to that data, how you can mitigate those risks down. And if you get to the end of that process and you've dealt with all the risks, happy days, away you go, document it, keep that. We might ask for it at some point. If you get to the end of the process and you still have a high level of risk, you need to come to us and consult with us so that we can cast an eye over it, we can provide our advice and guidance. We may assess that you've been overly concerned with your risk and that actually the risk isn't as great as you thought. We may go the other way and say the risk is horrific. There may be the circumstances where we suggest you do things a different way, or we, in very serious circumstances, we may issue an order banning you from doing that processing. And an example of that would be in relation to some processing Facebook was planning on doing earlier in the year, in relation to, I think it was their dating app and things, but you know, Facebook getting everywhere. The Irish Commissioner said, under no circumstances should you do that until we've had a discussion and gone through the process, because they want to understand how things are going to happen. So you need to be documenting all this, and there's a number of resources on our website that can help you with this. Controller self-assessment questionnaires, data audit document, duty to keep records, so you're recording all this information, and then lawful processing and DPIA. So have a look at those and see how you get on with them. We're here to answer any broad questions if you have them, so let us know. Step 3 then is to remember that individuals have legal rights. In relation to data protection, the law provides an entire section, entire part of the law deals with legal rights, so that individuals have the right to access the data that you are processing about them. They have the right in some circumstances to ask you to correct it. They have the right in some circumstances to ask you to erase it. And so you need to understand that individuals have these rights. You need to be able to recognise requests that come in, somebody exercising those rights. We tell people that it's really helpful if they actually say which right they want to exercise and start referring to data protection law in the requests that come in, but they do not necessarily have to do that. So you need to skill up staff to be able to recognise these requests, because there are timescales involved with them, and there's a requirement to respond. You want to have as much time as you can dealing with them rather than waiting for them to come to the right person. And you need to look at the things that you need to do in the workplace in order to respond to those. So who do you need to speak to about subject access requests? How are you going to gather together somebody's data? How do you, understanding how you're going to do that will cut down the time it takes to respond to requests and mean that you can deal with them efficiently. Step 4 then is making sure that individuals know what is happening with their data. And this is staff, so staff know what you're doing with their data, but also your clients, your customers, whoever you're dealing with. Make sure that they are aware of what is happening with their data. So having a privacy notice that you provide to people when they sign up with you, that's on your website, that's available, that people can look at, telling people what's happening with their data so that they know what's going on. A number of queries we get here, people asking whether there's been a breach of the data protection law, is less about what was actually done, more about the fact that people don't know that that's happening. Once it's been explained to them, once they've had a discussion with the organisation, they understand what's going on, they've seen the privacy notice, that takes that away. But things shouldn't be a surprise in the most part for people about how their data is being used, so make sure you let them know what's going on. And we've got advice on our website about what you need to put in your privacy notice, which is somewhat more extensive than it's been in the past. So if we go to step 5, you need to be able to understand, define and document the workplace's boundaries about how personal data is used, so that your staff know what they're supposed to be doing with the data, know what they shouldn't be doing with data, so they're aware of the boundaries. And because I have to get a good omens quote in here if I could help it, because I've been asked by one of my staff, one of the staff, Neil Gaiman and Terry Pratchett say in Good Omens, most of the triumphs and tragedies of the world are not because people are fundamentally good or fundamentally bad, but because they are fundamentally people. And so you need to be clear to make sure that everybody understands what they need to be doing, because in 99% of the time people don't set out to do it wrong. They don't set out to be malicious, do something that they shouldn't do. It just happens, something happens. So work out what that might look like for your organisation. Make sure your staff know what they should and should not be doing with the data. Add to risk registers, data protection as a topic, so that it becomes a board level concern. So you're getting buy-in from the top, and make it clear what's expected. And on that one, we've got an accountability and governance document on the website that will help you understand that. Moving on to 6, there is an obligation for organisations to report data breaches to this office where there is a risk to the individual's significant interest as a result of a breach. And so that might be something being sent to the wrong person. And I think we've all done that, haven't we? Where you sent your email to one person and your wonderfully helpful Outlook has picked up somebody else's address and sent it there instead. I know I frequently have I'm just going to check my sent box and make sure that that did go to the person I was expecting it to go to. A little bit of a wrangle with myself. But various things can happen, and we've got a data breach case study that we'll look at in a moment, where you can all wonder about what you would do in the circumstances and hope to goodness that they're not circumstances you as an organisation finds yourselves in. But there is this obligation to report breaches. There's an obligation for you to handle breaches appropriately internally. As I say, breaches that have a risk to the individual's significant interest need to be reported to us, and they need to be reported within 72 hours. There may be breaches you assessed that don't meet that threshold, so don't need to be reported within those 72 hours, but you still need to handle them internally. Document what you did, make sure you're clear about lessons learned, so you can try to make sure it doesn't happen again, build processes around that, and so that you can deal with any queries that the individual might have. The law requires you, where there is a high risk to the individual's significant interest, to talk to the individual, to let the individual know what's gone on. But you may decide in a spirit of openness and transparency that you're going to do that regardless, and that's for you to decide. But certainly if there's a high risk to the individual, then you need to be letting them know and ideally supporting them through the process. And in the last few years there's been countless data breaches, some of which have been handled really badly and some of which have been handled really well, and not here particularly, but high profile breaches across the globe. Certainly there was the TalkTalk breach where the person stood, I think it was the chief executive, stood in front of the camera and basically didn't know what was going on, which was not a great way to deal with it. Then there was another breach not so long after that, I think it was ABTA that did it, that had gone through this process, had worked out how they were going to handle breaches. They'd had the advice and guidance ready to give to people. I think people's credit card details had been compromised, and they had all the details about how you go about changing credit cards, numbers. They were going to support people through that. I think pick up some financial penalties involved with that sort of thing because of the breach that had occurred. And you just got a better sense that you were not necessarily happy the breach had happened, because I don't think we ever are. But if you had been a customer, that was a much more positive engagement, I think, than the headless chicken routine that other organisations had. So think about your data breaches, your obligation to report them, but also to handle them internally. On our website, we have the reporting mechanism, so you can visit our website, put details in that we request, so information about yourselves or your organisation as the controller, details about the breach, what has happened, what you've done about it, what you're planning to do about it. But what we would say is, please can you not tell us the details about the individuals involved? I don't need to know whose email address was the wrong email address to which something was sent. We don't need to know what the details were, to actually see the piece of paper that was sent to the wrong place. If we need that, we will ask. If we get the data subject coming and making a complaint, we will follow up with you for more information, but we do not need in the first tranche of reporting information anything about the people whose details were compromised, because you've done it again. And it's never great when you do it to the regulator. So yes, so we'd like to know what's happened, but we don't need to see what it was that was compromised. And then the 7th step is making sure the relevant people inside your organisation and that are conducting activities for you, so processes, understand all of the above. So they know what is expected of them. They can answer questions when asked. We get the wonderful one occasionally when you are asked at a till if you want to leave your email address, and then you say, well, why would I do that? And they say, oh, GDPR says we have to, and things like this. And you think, no, that's not the reason why. Or you're asking a question and they can't answer because data protection says I can't, or these sorts of things. Educate your staff so that they are aware of the answers to these questions. They understand the processes. They understand why they're doing what they're doing with data. Because again, it's the openness, the transparency, the honesty, the confidence of the organisation if people understand. So all you need to do is looking at training records, circulate relevant policies, little spot checks, mystery shopper activities maybe, I don't know. We've deliberately left that box blank because you get to be nice and creative here about how you're going to articulate this to the people that matter, the people that need to know about how data is used, and about what the boundaries are, because you know your organisation's best and you can come up with something unique perhaps. And if you do come up with something that seems a bit unique, it'd be lovely to hear what you're doing, because then we might be able to make it slightly less unique and slightly more common practice. And then the last step is that you are likely to need to register with us here at the Office of the Data Protection Authority. So we have a register of organisations. There's a requirement to register with us before you process any personal data, unless at the moment you are processing only for what are known as the core business purposes, or if you are a charity. So core business purposes are if you're only holding information of accounts and records, so you know who your clients are and how much they owe you, type of information. If you are processing data only about your staff for staff administration purposes, or if you are marketing your own goods and services, you do not need to register with us if you are only doing one or all of those 3 activities. If you're doing anything else with personal data, you need to register with us. And that exemption is going to fall away at the end of the year. So if you don't need to register now, you are likely to need to register on January the 1st. You can do that online. We're not going to be here January the 1st, but if you feel like you wish to do it, you can do it online. And you need to maintain information internally about your registration. There's a £50 fee unless you're a charity, and that's an annual process. So we will send you information about renewal before your notification renewals. Registration. It's registration now. It's notification under the old law. I knew I was going to do that. Registration. Right. So we move on to the case studies now. So there are 2 case studies. We have one case study about new processing activity and what an organisation may need to do about this new processing activity, and the other case study is about reporting a personal data breach. Both case studies involve our fictional estate agent known as Moving and Shaking, who you may have seen in our transitional guidance that we produced earlier in the year. We're keeping this one going for as long as we can. We may run out of things we can get Moving and Shaking to do, but we're going at it at the moment. So on your table, can you have a discussion about the case study you've been given? And then there are some questions at the bottom to answer, and we'll feed back to the group in about 10 minutes' time. If I can draw the discussions to a close on your tables and open it up to the room, we'll take case study 1 first. So Moving and Shaking, our estate agents then are going to be taking on the management of a supported living facility that comprises 20 flats for people in need of extra support but who do not require the level of care provided in a residential or nursing home setting. Moving and Shaking are the joint controllers with that company, with the company that owns the facilities, and the contract governing this is all sorted, so we don't need to worry about the joint controllers contract. But all the responsibility for making sure there's compliance with data protection sits on Moving and Shaking shoulders. They need to do the things they need to deal with all the things compliance-wise. But the property owner, you'll be pleased to know, in a joint controller relationship, however you divvy out the responsibility, remains jointly and severally liable for if it all goes wrong. You might not ever want to be the person that says, I'm not going to do any of the compliance myself, I'll leave it all to you, but if it all goes wrong, I'll be jointly and severally liable for it. You might want to have a level of control, but I was trying to make it easier. So they're going to need to manage the supporting living facility, decide who's allocated a flat, put in assistance measures, and provide general welfare monitoring. So they will need to have some special category data, they'll need health data in order to divvy out the flats and to put the right assistance in place, as well as the usual things for managing rental property. So those tables that had that activity, what did you think they needed to do to reflect the new processing activity in the documents they already have? And they already have privacy notice and policies for handling client data. What else do you think needed to be done from those tables? Yes, it'll be updating policies, updating privacy notice, finding which lawful processing condition you're relying upon for the processing of that special category data. And whilst there'll be a contract in place between the tenant and the moving and shaking for the provision of the accommodation, you cannot use the contractual clause for processing of special category data. So you need to look at parts 2 and 3 of Schedule 2 for a special category data lawful processing condition, which is likely to be around the provision of some form of health and social care in this case, but you can't rely on the contract condition. So you need to make sure you look at not only updating your privacy policy, but finding out which conditions you're relying upon and putting that in the document. But yes, we have updating policies, we have training staff, as we said. Staff, unfortunately, are the you have the technology can go wrong and you have the staff go wrong, and quite frequently it's the staff, not that they're doing it on purpose, but something happens. There's the wonderful little cartoon image that goes around occasionally of a boxing ring, and in one corner you've got a huge stack of technical equipment, firewalls and computers and all the rest of it, and then in the other corner you have this other chap, and then the referee in the middle is saying, and in this corner here we have Dave. Up against this technology, and of course somehow or other Dave's going to manage to find a way to break it, whether he's doing it on purpose or not. So training staff, looking at data protection impact assessment, because you're looking at special category data, and certainly they haven't got any special category data in relation to clients otherwise. Looking at their internal breach procedures, their breach log, and the security they put in place around that, and defining boundaries. So how do you use that data? So yes, you'll need to give the on-site staff that information, because they'll need to know what they need to do to keep the tenants safe, but then you also need to understand what they do with that and where the boundaries are. So if we look at the other case study now then, reporting a personal data breach. I'll just read out the scenario for those that don't have the other bit of paper. On the afternoon of the 29th of July, Moving and Shaking became aware that a member of their staff had disclosed the name of a tenant of a property to a third party. The tenant was a woman who'd recently moved out of another of Moving and Shaking's managed properties that she had shared with an abusive former partner. The woman's former partner called Moving and Shaking and tricked the staff member into disclosing the woman's new address by pretending to be her brother, who wanted to send her a birthday card. Fortunately, another staff member overheard this phone conversation and realised it was a ruse. They were able to quickly alert the tenant that her details had been disclosed, and later that afternoon they made sure she was safe, apologised and rehoused her. They completed an internal breach log, identified the need for enhanced safeguarding training for new members of staff, and called a whole staff meeting to ensure everyone was aware of what happened and how to stop it happening again. The following week, on the 5th of August, Moving and Shaking, mindful of their requirement to report breaches to this office, reported it. They completed the breach report form, providing full details of the tenant's name and address and the name of the man the information was disclosed to in error. And they also filled in the breach form, and there's a picture of that on there, but I'm not going to say what's in there because that might give the game away. So based on the scenario here, the tables were asked to think about what they did right. So what good practice or or actions that were appropriate did you discover? Yeah, they missed the 72 hours. Thank you. Anything else? Apart from obviously doing it in the first place. Yeah, so again, they then provided all that information again. You never know, somebody, the guy's brother could work here, and now you've just provided all her new information to us, and they've gotten hold of that, and you've got to go through that process again. There was that secondary breach. Anything else? That's one we do get quite a bit, is that somebody will put their own name in the controller box rather than the controller. You can take full responsibility for it if you like, but actually it's the organisation name generally that goes in the controller field, not the person, and then your name goes further down. And you'll see that that's all the stuff we've got on there. And so thank you very much for having a look at those activities. Moving on, now that we're just about to close, any questions or any other points anyone wishes to raise at this stage? Okay, so now I teased our little blue tits. I'm going to put them back on the screen. And you may have noticed a couple of us wandering around with blue tit badges on. We are looking at what we can do to change behaviour, shift culture and reduce harm. Now, it's great that we can get you all together in a room and provide you with content, but the fact we've got a waiting list that means we could run this course again tomorrow and half again the day after shows that there are people out there that need to find out information and that want information. And then there are people out there that need information that don't yet know they need information, which is possibly more important. So what we're looking at is a little project we've been put together that will seek to get the message out there about data protection, to look to do this change behaviour, shift culture, reduce harm, and sharing the messages about compliance and across organisations. So we are taking names at the moment. We'll be able to send you resources, and the idea is that you can then go back to your organisation suitably tooled up with resources that you can start passing messages on and getting it out there and to try and grow the data protection community. But we're looking to do it in a way where we can perhaps measure the impact of that, and so we can demonstrate how good Guernsey is at organisational and cultural change. Thank you very much.
For more information about future events, please visit odpa.gg/events. Also, if you need any more help and advice, please visit our website odpa.gg, or alternatively, you can email inquiries@odpa.gg. That's inquiries with an E @odpa.gg. Thank you very much for watching and for listening. Goodbye.